So, what is the legal position when it comes to challenging the EC proposals, the delineation proposals? As a result of several Court of Appeal cases, as it stands, the legal position is that the EC's proposals cannot be subject to judicial review. Court of Appeal in the case of M. Kulasegran and another in against SPR is Malay translation of EC, and two others held that the judgment was in Malay, so I've paraphrased it and translated it to English. That EC recommendations were merely proposals and not a decision which can be subjected to judicial review. Therefore, the judicial review filed for these cases were premature. Also in the case of Peguam Negara against Chan Su Chong, this is brought by some voters in Malacca, the Court of Appeal held, again the same thing. The first respondent's findings and proposed recommendations are not binding or have any legal effect, as the proper authority for deciding on the delimitation of constituencies is the House of Representatives. Therefore, applying the above principles to the facts of the present case, we held that the findings and recommendations of the first respondent did not come within the ambit of Order 53. This is the procedure when it comes to judicial review. And that the learned High Court had gravely erred in granting leave. So, conclusion. First, as I've mentioned, the EC's proposals when it comes to redelineation are at least questionable. They do not appear to adhere to the principles of the 13th schedule. The EC's proposals perpetuates malapportionment and give rise to allegations of gerrymandering. This would, of course, in turn have an effect onto a voter's fundamental right to vote. So, the redelineation proposals have the opposite result of making elections fairer. Unfortunately, apart from filing objections, there seems to be no other avenues available for affected parties to challenge the proposals. So, the question is this. When the court held that these proposals are not the decision and they cannot be judicially reviewed because they are merely proposals, the question is, when can an aggrieved party bring an action to court? Because if you're saying that at that point in time they are only proposals, when can they bring a matter in court? Is it after the inquiries? But some of the judicial review applications were after the inquiry has been made or has been conducted. What if the EC does not take into account or dismiss your objections? What can be done then? Does it mean then that you can only bring an action once the report is prepared and the Prime Minister tables it in Parliament? But then you've got the issue of parliamentary privilege, where our constitution says that nothing which is in Parliament can actually be questioned by the courts. Does that then mean that you only have that small window where the EC gives the proposals to the Prime Minister, but the Prime Minister has not yet tabled the proposals in Parliament? But how would anyone know? Because it's not as if they're going to announce it. So effectively, the decisions in the Court of Appeal has made it such that aggrieved persons who feel that the EC have not adhered to the constitutional principles would now appear to not have a legal recourse available to them, unless we take it that there's that small window of opportunity which I have mentioned. So all this, ladies and gentlemen, it goes to show that there is a problem. When we have the Elections Commission is supposed to carry out its duties according to the Constitution. When you don't have an Elections Commission that does that, you should then be able to bring that matter to court and ventilate it.
Shah, you have to wrap up. Sorry.
Yes. So, if the courts are saying now that you can't even do that, where do we go?